5 seconds to go. Start. All these four appeals were decided together by the High Court in its common judgment and order dated 28th June 2019. As noticed, the present appeal relates only to RFA number 247 of 2014 pertaining to OS number 293 of 2012. Therefore, dilation on all the factual aspects of the four civil suits and respective findings of the High Court may not be of direct relevance for the present purpose, but for the fact that they relate to cognate matters and the appeals have been decided by the common judgment for a comprehension of the views of the High Court, it would be profitable to take a brief note of the findings in the impugned judgment. The High Court observed that the common issue arising for determination in the appeals was regarding the character of the subject property, namely theatre with land and shopping complex with land, after the five sisters, that is, respondent number 1 and respondent numbers 2 to 4, entered into the partnership agreement. The High Court adverted to the question as to whether the properties obtained by them under the partition would partake the character of partnership assets after the formation of partnership, and took note of the principles as to how a property could be brought in as a partnership asset expressly or by conduct. The High Court observed that merely because separate properties of the partners were used for the business of the partnership, it would not entail a presumption that the properties were brought in as partnership assets. After dealing with the relevant clauses of the partnership deed as also the other two sale deeds dated 10th November 2004 and 17th January 2004 executed jointly by five sisters, the High Court ultimately held that the properties obtained by these five sisters under the partition deed continued to be held as co-ownership properties even after execution of the partnership deed dated 28th January 2003. The High Court therefore held the properties to be co-ownership properties and consequently upheld the judgment and decree of the trial court in relation to OS number 497 of 2006 and OS number 181 of 2007 for partition of properties. The High Court observed and held as under: having held the properties to be co-ownership properties, the suits OS 497 of 2006 and OS 181 of 2007 for partition of the properties are liable to be decreed. The judgment and decree of the trial court are only to be upheld, and I do so. Reverting to the two civil suits filed by the respondent number 1, the High Court in the first place referred to OS number 238 of 2012, wherein the plaintiff respondent number 1 had claimed prohibitory injunction against the defendants. It was noticed that the relief was claimed by her in the capacity of a partner of the firm against other partners. The High Court observed that the partnership was an unregistered one, and therefore the suit was barred under section 69(1) of the Indian Partnership Act 1932. Hence, the decree of the trial court dismissing the suit OS number 238 of 2012 was affirmed. After dealing with the aforesaid three civil suits, the High Court referred to the questions involved in OS number 293 of 2012 and noted the grounds on which the relief was claimed for cancellation of the sale deed. The High Court summarized the grounds of challenge as follows. In OS 293 of 2012, from which RFA 247 of 2014 arises. The relief claimed is for setting aside Exhibit A1 sale deed. The grounds on which the sale deed is sought to be set aside are: stop.